Attendez, il faut que je reprenne. Voilà, j'arrête le partage.
Professora, você quer combinar com ele para compartilhar depois que você fizer a apresentação?
Do you want to wait my introduction, Professor, before sharing your screen? It's up to you.
Yes, but I have a problem with my screen. Check. Cliquez pour fermer. Okay, that's it. Give me 1 second.
Sure.
Check. Ouais, okay. That's okay.
We see it perfectly.
Okay.
We can start, Professor?
Yes.
Okay, thank you. You can start, Professor. Just wait for the message that is recording.
Okay.
Yeah, okay, thank you.
Sure.
Recording in progress.
Hello, everyone. Good afternoon. We are here with Professor Laurent Sermet. It's a really pleasure for me to be introducing him this afternoon. He is a professor at Sciences Po, which is the Institut d'études politiques de Paris. So it's a really pleasure to be with a professor from one of the most important politic and social centers in the whole world. He is a specialist in human rights, French law, European law, humanitarian law, developed law, among other subjects. He was a professor at the Faculty of Law and Political Science at the University of Marseille. He worked on the international higher education and research missions at the initiative of the Asia Pacific Office of the Agence Universitaire de la Francophonie. Professor Laurent, it's a pleasure to be with you. We're going to talk today about the responsibility principle in public international law. The floor is yours. Welcome.
Thank you, dear colleague. I hope you can hear me okay. Is it okay for the sound?
Yes,
okay.
Perfect.
Just thank you for the welcoming address. But I'm not coming from Paris, but from Aix-en-Provence in the south. And this afternoon, because it's the second part of the afternoon, I was at the sea, in the Mediterranean Sea. So you cannot do that in Paris. You can do that in Marseille. So today, I would like to introduce the question of the responsibility principle in public international law. This question is a main question in public international law, and I will focus on a specific part, but I think the most important one in terms of public international law. I mean the state responsibility in international law. And I would like to draw, if possible, for all of you, some consideration about what does that mean for a state to be held responsible for its obligation, but namely the breach of its obligation. I would like to introduce this question, which is a very important one, with 5 points. 5 points, and every diapositive, sorry, the word in English I don't have, it doesn't come, is 1 point. So I come with the first point, and I would like to introduce as the first point, I would like to introduce what is very common, doctrinally speaking, but it's not always understood by our students, and maybe also by the colleagues who are not in charge or interested with public international law. This first point, as an introduction, this first point is about the distinction between primary obligation versus secondary obligation. In French, we say les obligations primaires et les obligations secondaires, primary obligation and secondary obligation. Very briefly, we can say that the question of state responsibility is in the actual understanding of public international law, is understood as a secondary obligation. If you want, doctrinally speaking, to say, I have understood the question, you say responsibility is a secondary obligation. I would like to quote, to begin this distinction, I would like to quote the famous Vienna Convention on the Law of the Treaties. As you know, this treaty dates back from 1969. And this treaty is, let's say, the constitution of the treaty, is the main legal basis for the state about the legal question of what is a treaty obligation. I would like to quote within this convention, Article 26. If you want to follow what I'm saying right now, you can go to this link. Maybe I can copy it for the public. Converser, yes. Tout le monde. Yes. Is it okay? You have the link?
Not yet.
Not yet. I send it to everyone. It should be okay in the conversation.
I don't get it on the chat, but I will copy it to the students, Professor.
Amina, chat.
Yes, I'll do it.
Okay. So you can go to the text and to Article 26. This article, one of the famous articles about the rules, Pacta sunt servanda. Pacta sunt servanda. In French, les traités sont obligatoires. Treaties are committing states. The exact thing of this article is every treaty in force is binding upon the parties, I quote, is binding upon the parties to it and must be performed them in good faith. Very commonly, pacta sunt servanda is associated to, it's an obligation to execute, okay, and it has to be done in good faith. I would like to precise the two aspects of that rule, of the pacta sunt servanda rule. One, first component, every treaty in force has a binding effect. Binding effect, which means it is compulsory. It's not a moral understanding. It's not a religious understanding. No, it's legal. And because it's legal, it has a binding effect, first. And second, the state and every state party to the treaty has an obligation of execution, of performance. An example I took for the student who follow us, the famous convention of the elimination of all form of discrimination, racial discrimination, 1965. Okay, it's interesting to go into that convention and to search for A, the binding effect, and B, the execution effect. Binding and execution effect. Article 1 is about the notion of racial discrimination. So the text is giving the world what is the definition of a racial discrimination. And then this definition is compulsory for the state. And second, and here it's explicit in the convention, states parties condemn racial discrimination and undertake to pursue by all appropriate means and without delay a policy of eliminating racial discrimination. Okay, so you understand, one thing is to consider the binding effect of a treaty, and another, which is a complementary one, and another is to have and to conduct a duty of execution. So pacta sunt servanda is both as a primary obligation, the binding effect and the duty to performance. We can say, I go further, we can say that without any doubt that Article 26 of the Vienna Convention is not only a treaty rule, but it's also a customary law obligation, which means that if a state like France has not signed and ratified the Vienna Convention, it's not a difficulty, it's not an issue, because pacta sunt servanda also has a binding effect to France, despite any ratification of the treaty as a customary law obligation. Which means, and I finished this slide by analogy, every international obligation has a binding effect and has to be performed. And I mean, of course, treaties, the binding effect of the treaties, the binding effect of customary law, the binding effect of the general principle of law for the main sources of international law. What have been described until now is about the context, the notion of what is a primary obligation. I turn now, second slide, but still point one. The question, the very important question about, and I'm slow, step by step, introducing the notion of responsibility, the question of the breach of the treaty. So the breach of a primary obligation, for example, the breach of the definition of racial discrimination, or the breach, I come back to the previous slide, or the breach of not having by all appropriate means and without delay a policy of eliminating, of combating racial discrimination. When there is a breach of a clause, if we go into the Vienna Convention 1969, okay, there is 2 articles, and those articles are, for the first one, Article 60, is not giving very, very interesting answers. And the second is explaining why there is so small answers in the Vienna Convention. First, Article 60, when there is a breach of a cause, the consequence can be termination or suspension of the treaty. And a breach is defined as the Article 60b, violation of a provision essential to the accomplishment of the object or the purpose of the treaty. I go very fast, and I used to take very long time with my student to explain Article 26, Article 60. But we understand that the solution given by the Vienna Convention in 1969 was, okay, there's a breach of the treaty, and then the consequence can be the termination or the suspension of the treaty, which is not good. It means we stop having a legal relation. So it's as I have written, an imperfect solution. It's a very imperfect because because the international law say, okay, there's a breach, so we stop. And it gives the state the right to go out of the treaty, and it means that public international law is defined as a contractual legal system. There was a contract, the contract is not applied, so we go out. But it's very imperfect, and it's not very interesting. And added to that, you have to bear in mind that public international law is imperfect in regard to access to international judge. So it means there is a breach, but is that breach an essential provision, as Article 60B is stating? As there is a judicial imperfection in public international law, who is in charge to prove the breach of the treaty? Okay, so you can have the conclusion about Article 60. That Article 60 shows that the solution that the state have allowed in 1969 was very low. It was very low about the notion of there is a primary obligation, and then what happened when there is a breach of. And then we go to Article 73, and you have the explanation. That article of the Vienna Convention says that provision of the convention shall not prejudge any question that may arise from international responsibility of a state. So it's clear. It's very clear. The diplomatic agreement in 1969 was, no, we have no time. It's not now that we will deal with international responsibility of the state. What we can, and I finish with the point one, what we can say about after primary obligation is the definition of the notion of secondary obligation. Secondary obligation is the setup, the rules, the international rule that are that help the state to execute the treaty when there is a breach, of the treaty. So we can understand that the first approach, that when there is a breach of a primary obligation, there are some secondary obligation in terms of responsibility to execute, the treaty. So it means that primary and secondary obligation are working closely together, are due to work together. I would like to say after this first point that in the actual state of development of international law, that the state of international law has done much about primary obligation and has done very little with secondary obligation, very little, which is another proof of the imperfection of public international law, I come now, point two, to the first case an arbitration case that dealt with the question of the principle of state responsibility. That was 2 centuries ago, about 150 years ago, and it's the famous case of the Alabama arbitration, which is considered, doctrinally speaking, as the first modern arbitration and application of the state responsibility. You can find the text in English in that reference. So I send it to. I don't have conversation. Is it okay? I don't have the conversation facility. It's here. I think it's here. No.
I can copy it for you,
okay,
Professor,
please,
if you want.
Please. That's
I'll do it. Don't worry.
Okay. So I would like to present briefly the Alabama arbitration with the fact, two questions, and findings. First, the fact that arbitration is about the conflict in Northern America, in the United States, between the South and the Northern force. As you know, there was in the 19th century, a huge conflict between the 2 parts of the United States. Ideological war between 2 parts of the country. And we can say, retrospectively, that it was and clearly an internal armed conflict, a national armed conflict, internal armed conflict, okay? And one of these example of that war, civil war, was about the implication of the British government. Indeed, a military vessel, namely the Alabama, was constructed, was equipped and armed in Great Britain. So it means that the South American force were allowed to have a part of the mean of the war in Great Britain. In Great Britain, which does not mean with the help of the Great Britain, which does not mean with the direct help. But in a way, the British government was implied with the South military for the South military naval American force. So there was, of course, a prejudice caused to the Northern force. And the British government had, and here it's a primary obligation, had a duty of neutrality, an obligation of neutrality. So this, let's say, help, that was the fact, this help, was it a breach of the neutrality obligation? And that's already the first question. So I'm sorry, it was not well written. Responsibility. British. Yes. This commitment, factual commitment of the Great Britain, was it an implication of the British government? And the second main question was about, is the prejudice cause, if it is indeed caused by the British government, is it a direct prejudice or is it an indirect prejudice? And here you understand that we are in the field of responsibility. This arbitration was considered as the first very modern arbitration because the tribunal, arbitration tribunal, decided not in equity, not in politics, but on the basis of international law. And the finding was, yes, construction, equipment, armament of the vessel was interpreted as a violation of neutrality, that the British government has not respected. So there was a breach of a primary obligation, and then there was an obligation to repair the breach. So you understand that with the two first points, this arbitration and the distinction between primary and secondary, that everything that is linked to the legal obligation when there is a breach is a secondary obligation, namely a responsibility, a principle of responsibility in public international law. I come now, third point, to an interesting legal point, but conceptual because it has not been adopted, which can be presented as a dual state responsibility. And this goes back to 1976. At that time, there was a study by the International Law Commission about a proposal, a distinction, a new distinction. And you have, Amina, you have also here the document. If you can copy it, you have the document. It's in English. Okay. Thank you. There was a distinction, a very interesting distinction at that time. And this distinction was based on Article 18 of the study. This Article 18 decided to make a distinction between what is an international crime on one part and what is on the other part an international delict. So there would be two kinds of state responsibility. One would be a criminal responsibility of the state when there would be a breach of an international crime, and the other would be a delictual responsibility when there would be a breach of an obligation that is not a crime, Okay. So this article is a very interesting one because it allows you to understand what was in mind of the International Law Commission, of the member of the International Law Commission. You have four articles, you have four paragraphs. Paragraph 1, 18.1, is a breach of an international obligation is an internationally wrongful act. Okay, the notion of wrongful act. Okay, the breach is an internationally wrongful act. You remember we had previously, less than 10 years before, in Article 60, we had the notion of essential an essential provision to the accomplishment of the object or purpose of the treaty. It's not the same thinking. It's not the same thinking because in the Vienna Convention, Article 60b, it was about the possibility to stop the execution, to suspend or to stop the execution of the treaty. Here we are in the notion of responsibility. So I come back. So now the term, and this term is still used today in 2021, the notion of international wrongful act. I turn now to Article 18, paragraph 2. A crime, a internationally wrongful act, which is a breach of an international obligation so essential for the protection of fundamental interest of the international community, is recognized as a crime by that community as a whole. Okay, so here you have a standard. You have a presentation as a standard, which means an international crime committed by the state is an international obligation that is so essential that this is recognized as a crime by the community as a whole. Okay, and then, paragraph 3, you have the explanation. There is a crime, paragraph 3a, when there is a breach of every obligation linked to peace and security, like aggression. B, there is a breach of the right of self-determination of people, such as establishment, maintenance by force of colonial domination. C, there is a breach of every important human rights issues such as slavery, genocide, apartheid. And D, which is very, very current to us, a massive pollution of the atmosphere or the seas. So that was already, namely almost 40 years before us, the notion of massive breach of environment was considered as a crime of the state. Please have in mind that it's important for the well understanding. I'm not talking in that lecture about the individual responsibility at international level. I mean, international criminal court. No, I'm not talking about the individual responsibility. I'm talking about and only about the state responsibility and the possible crime committed by a state. And then I come back and finish with Article 80, paragraph 4. Any international wrongful act which is not a crime constitutes an international delict. So if we have exceptionally a crime, the rest is considered as a breach of an international delict. You have to bear in mind that this dual state responsibility was a project, and the state did not accept that dual responsibility. Namely, they didn't want, and very clearly, that the possibility of recognition of a criminal responsibility of the state. So that dual state responsibility was only an attempt, like a doctrinal attempt, to have a more integrated state of public international. Maybe in 50 years, in a century from us, this dual state responsibility would be recognized. But as to now, it is not. It is not. I come to a fourth point, and it is an analysis of what I've said about the dual state responsibility, this hierarchy. And indeed, there was, if it is, of course, just an attempt, and it's not positive law, but there was an attempt of a double hierarchy. I mean, on one side, the first hierarchy, which would be based on Article 18, which distinguish between A, the delict, and B, the crime. So we understand that the crime is much above. So the delict is the first and the general law of secondary obligation. Everything crime is a delict, and above there would be a criminal breach and then a criminal responsibility. So there was on one side, there could have been on one side a hierarchy on state responsibility, namely Article 18 of the International Law Commission study, and on the other part, but this is much more positive law, and I come back to Article 53 of the Vienna Convention, and this treaty is a binding treaty, despite there are numerous reservations to it and to this article especially. Article 53 has indeed adopted the notion of peremptory norm of general international law, namely the jus cogens. So there would be, on one side, a hierarchy between the crime and the delict in terms of secondary obligation, and on the other side, there would be another hierarchy, namely the jus cogens and the non-jus cogens obligation. So this double hierarchy does not exist. It's just an hypothesis, okay? Okay, it does not exist, but I would like to quote the famous Versailles Treaty. As you know, this treaty has allowed the First World War to end with legal solution. And Article 231 on one side and 227 on the other side dealt with, on one part, the notion of responsibility, on the other, of sanction. And those terms were used by the treaty itself, namely the conference, the diplomatic conference, namely the state parties to it, and then the treaty, and then the text of the treaty. Article 231 has dealt with responsibility, okay? Allied and associated government affirm, and Germany accept, you remember the notion, the context of that treaty, accepts the responsibility of Germany and her allies. So here we are in the field of, let's say, the delict, the international delict of Germany. And then if we turn to Article 227, it's another thing, because we are here in the field of sanction, and you know that William II of Hohenzollern was confronted to the German emperor a breach of supreme offense against international morality, and sanctities of treaties. Okay, Article 227. That article was about an individual responsibility, namely the emperor, the German emperor. Okay, so we are not dealing with individual, but you can see with those two articles that there was a hierarchy. On one side, there is the traditional responsibility, namely Article 231, and on this other side, something much more important, something much more deeper, namely the crime. Okay, and I finish the presentation with that was 20 years ago, and that's still on the table. It's still the International Law Commission. It's still the International Law Commission. It's still a project, but this project now is, let's say, very clear and is about to be accepted by the state, not in 50 years, maybe in 5 years, because there are still some difficulties, but namely, study that has been delivered 20 years ago is still discussed by the state, and I mean, it's still discussed in the fixed commission of the General Assembly, which is the legal commission of the General Assembly of the UN. But we have the result. And I finish, and you have here, if you have only one thing to mind of all what I've said, is very actual, which is also very diachronic, historic perspective. It is this slide, and again, you have the possibility to have access. You have the link to have access. I mean, if you want to copy it. And here, I would like to quote 4 articles. The first one is the notion of international wrongful act. Okay, international wrongful act, you remember, it was already used by the Commission, the International Law Commission, in 1976. Every international wrongful act entailed the international responsibility of the state. And then, and here we are in the deep heart of what is secondary obligation. And you have here the explanation, the clear explanation of the secondary explanation, Article 29 of the study, 30-31. Secondary obligation is first the duty to perform. When there is a breach of an obligation, of an international obligation, the state has still the duty of performance, continued duty of performance, the continued duty of the responsibility state to the obligation breach. And you remember, this is linked to what I've quoted before, Article 26 of the Vienna Convention. So the first secondary obligation is the duty to perform, even if there is a breach. Second, cessation and non-repetition. The state responsible is under the obligation of see to the wrongful act, and then offer the state appropriate assurance and guarantees of non-repetition. I have violated the treaty, I have violated the obligation, and I present you the guarantee of non-repetition. This is the second main secondary obligation. And then, third one of the study, the reparation, the state has to repair. And this reparation is understood as full reparation of the injury. And the injury is defined as being the damage moral and the damage moral. So I turn back, and I have finished. I turn back to my first slide about primary and secondary obligation. Now we know that what is a secondary obligation, and you see down the slide a setup of international rules. Yes, you have now the setup. A, the state has to continue to keep on the performance, to keep on the execution of the treaty. That's the first secondary obligation. B, it has to give guarantees of non-repetition. And C, the state has to give full reparation. And if you understand this construction between primary and secondary is due to the very imperfect state of development of public international law, a law that deals with sovereign states. I hope I've been clear, and I'm waiting for your question. Obrigado por todos. Thank you.
Thank you so much, Professor Sermet. It was very interesting. That's an argument that students actually love during classes, right? And it raises a lot of questions. So I'll start with a question. Maybe it can help students as well to study this argument of the responsibility principle. So you said that secondary obligations is still to be improved, right? So we are improving this.
Yes.
Okay. But when we talk about the state responsibility, you linked it to the treaties. But in international law, we have many sources of international law. We have the customary source. We have for example, the decisions of the United Nations Security Council. I mean, for us to study the state responsibility, how can we understand the doctrine? I mean, you talked about this project of articles, but is there a uniform doctrine about state responsibility, whether it is linked to a treaty or to a customary source, or to, how can we understand this doctrine?
Okay, thank you, Amina, for the question. And thank you for the explanation of the question. So, right. Please, let's go back to the point one. Here, you see, by analogy, every international obligation based on an international source of law, international is under the obligation of pacta sunt servanda. You have to apply the treaty with the rule of pacta sunt servanda, but also the customary law with the pacta sunt servanda, not the pacta, but the A, binding effect, and B, duty to perform. When the state is linked by a general principle of law, by a customary law, by international decision of the judge, of international judge, it is binding. You quote, interestingly, the decision of the resolution of the Security Council. It is A, binding, and B, has to be performed. So you have, let's say, to go deeper into primary obligation and secondary obligation. On one side, you have many primary obligation and many sources. You put it, customary law, general principle of law, and so on, and so on, and so on. But there is only one set up of rules as secondary obligation. That is clear. You have many, many, many possibilities linked to primary obligation and only one single doctrine, continued duty to perform, cessation and non-repetition, and reparation. And here, A, B, C, duty to perform, cessation, non-repetition, reparation. And this is the doctrine. This is the doctrine. Today, this doctrinal perspective, the setup of rule, is about to be fully accepted by the state. About. And this is the notion, this is the content of secondary obligation, which is due to the imperfect state of development of public international law.
Okay, thank you. On the first day of our event, we had a lecture with Professor Hazek that was talking about the international jurisdiction as well, and the things that prevent it of improving. And he talked a lot about sovereignty in international jurisdiction. So do you think we should look to sovereignty in a different way in order to see the improvement of the responsibility principle? I mean, is that the key aspect of it in your opinion?
That's a very interesting point. That's a very interesting point because, as you know, today the notion of state sovereignty is, in a way, and in a way not, old-dated. We prefer to use the term of not the sovereignty of the state, but the responsibility of the state, the R2P. You remember what was done in 2005 by the head of state at the UN General Assembly. There's a responsibility to protect, not the sovereignty to protect, but a responsibility to protect. The responsibility to protect, when it was used in 2005 by the head of state, okay, it was not thought as secondary obligation, but as primary. Time has changed in order to say that sovereignty must be reduced. Sovereignty means the state is not obliged. Responsibility to protect means the state is obliged. So we are indeed in the field of primary obligation. We are indeed in the universe, in the concept of primary obligation. Now I turn back to the deep heart of your question, the judge, international judge. Yes, if public international law could go further, the state, the judge, the access to the judge would be systematic. And then, if the access to the judge is systematic, you don't have to draw this distinction between primary and secondary. But today, it's not the case. States are still sovereign, and states still go to court only if they accept, because they're sovereign. That is why, understand, the state of development of international law is today very strong as primary obligation, and very weak in regard to responsibility. Very weak. And it's not good. It's not good.
Yes, I find it very interesting, especially when we talk about treaties interpretation, because usually each state interprets a norm or term in a different way from one another, right? And it impacts a lot when they come to responsibility. And
exactly.
That's very interesting. Do you want to talk a little bit about it? Especially because we have like to translate. We were talking about it also in another lecture. So I'm just trying to for the students that are with us, I'm just trying to put informations together to add to this lecture. We are talking also about the translations of treaties and how a state may prefer a term instead of another, because they are trying to protect themselves, right?
Interpretation has been dealt by the Vienna Convention on the Law of the Treaty. It's a main aspect of the law of the treaty. So you can translate. It's a main aspect of primary obligation. It's a main aspect of primary obligation. And the notion of good faith that we have quoted before also applies within the field of interpretation. You have to give as a state. You have the right, you have the sovereign right to interpret the obligation of the treaty, but you have to do that in good faith. In good faith. Another question of raising in regard to interpretation is what I've mentioned earlier about the possibility of, I do interpret the clause, but I say it's not a breach. And you are a state party, we are together state party, and you say, no, you interpret, you say there's no breach. There is a breach. So we are facing two competitive interpretations. Who is delivering the right and wrong in this case if there is no judge? That's the point. That's the point. If I'm the China and you are Taiwan, let's say Taiwan is a state, okay, I say that, it's finished. Legally speaking, if I'm a state, my interpretation of the obligation has the same value as the counterpart, same value. But because they have the same value, linked to sovereign interpretation, there must be a judge. There must be in somewhere a judge. Of course. So interpretation, yes, it's very important, and it's linked both to primary obligation, but also to secondary obligation.
Yeah, it's very, very interesting. Also, the distinction you talked to us about crimes and the wrongful act. It's interesting because could a state, Professor, report a violation if that state is not binded to that to that other state that committed the violation? I mean, if a state is not part of a treaty, okay, a certain treaty, could it report the violation of another state? How do you see that? I find that very interesting because it comes exactly to this notion. I mean, could we have like a public persecution in the international public law? That kind of that figure, you know?
Let's go back to Article 18. Okay? And let's go in Article 18 to Paragraph 2. A crime is a breach of fundamental interest of international community, which means it does not depend whether you are linked or not linked with the treaty. No. It's fundamental for Zimbabwe, as for China, as for Ireland, or Brazil, or Spain, whether they are or not. So it's an obligation linked to fundamental interest recognized by international community and recognized as a crime by that community as a whole. So it means, to answer the question, yes, indeed. In this context, whether you are linked by a treaty or not linked by a treaty, you have an interest to report to the state as being a third state and to say, no, you have to perform your obligation. You have to execute, you have to cease to act, you have to give guarantees of non-action and so on. You have to repair. As the notion of crime of the state, criminal responsibility of the state is not recognized, this distinction, this understanding is not possible. Today, okay, what is recognized is only, let's say, to understand, it's the paragraph 4 of Article 18. The international delict. Every violation is considered as an international delict. So it's changing the view, the point of view. If you don't have interest, to relation to the breach, then if you don't have interest, you cannot report against the state as another state. I hope I was clear enough.
Yes, thank you. Barbara wants to make a question.
Yes.
Barbara?
Good afternoon, everyone. I'm sorry, but my camera is not available right now. And I would like to ask Professor about the previous topic you were talking about, responsibility to protect. Yes. As you were talking about the R2P, I would like to ask about the conception of responsibility while protection, which is a term evocated by our former ex-president Dilma Rousseff at the United Nations Assembly in 2011, when she was discussing about the responsibility to protect civilians while a conflict is happening. So I would like to shed light into this term by the international law. So I would like to know how international law could fit into this reality, not only dealing with the prevention or repression of international issues, but being relevant while this issue is happening. I don't know if I'm clear.
Can you repeat the...
Yeah, the final, well, it's this term, responsibility while protection, is a term evocated by our former ex-president Dilma Rousseff, which is a term from international politics.
Okay.
But I would like to know how international law could be responsible not only for the repression or prevention of international issues, but could have a fit at being relevant while these issues is happening, during it's happening.
Okay. The notion of responsibility to protect is on one side very old-fashioned. It means only, it's a very obvious concept, which is when a state, when a government is in charge of the state, this government has the duty to protect its own population, which means the government has to prevent any international crime against its own population, which means massive crime of war, which means preventing any crime against humanity, which is also preventing any genocide or ethnic cleansing. Something very clear: the state has not to perform a practice of crime. So, and that was the issue in the Security Council with Dilma Rousseff when she was at the Security Council in 2011 with Libya. The government of Libya, namely Gaddafi, was on one side protecting and on the other side committing crimes. Okay. You said prevention and repression, but prevention and repression is the most interesting part of the responsibility to protect, to prevent, and to pursue. To prevent, to pursue, and to act in favor of. What I want to say is that today, international law is still very imperfect. You have to elaborate a language that is fitting with the state sovereignty. You have to push without saying you push the state. You have to use a wording that may be applicable. The real task of international today is effectiveness. It's yes, okay, it's concept. It's the conceptualization, but mostly is about effectiveness. When you say to a state you don't have the right to commit crime against your population, oh, okay, it's not a high standard. It's not a high standard. I'm sorry, I didn't answer maybe correctly with what you've said. Responsibility to protect is a good thing. Okay, there were 3 stages. First, the state has to protect its population. B, other state, international organization has to offer help. And the state, territorial state, has to accept. And third stage, if the 2 first are not applied, is the Security Council to intervene. And the real question is about, is this primary obligation of responsibility to protect, is it a real primary obligation, a real positive obligation, and is it linking, is it binding the Security Council? And we know that today, no, it's not. So again, we see that international law is weak. The level of development is weak. It's very weak.
Okay, Professor. I'll have other 2 considerations, if it's okay for you. If then any other student want to make him a direct question, just raise your hand. Can you talk a little bit about damage in this doctrine? I mean, is it necessary to be a damage in order to start this responsibility of the state? or is the breach enough? I mean, do we have to consider the damage itself?
That's a very good question. That's a very good question. The main condition for responsibility is the breach. That's the breach. In this. Well, you have. I did not want to go into this question, which is a very interesting one, a very legal, interesting question. You have two sides in order to admit responsibility. Either you see a fault, that's the French Code Civil, l'article 1382, article 1382, article 1382. La faute, the fault. And here you see the wording is not the fault. There's no culpability of the state. It's an act, namely a wrongful act. A wrongful act. It's not a fault. It's the breach. A wrongful act, an internationally wrongful act, is the breach of an international obligation. You don't consider intention, you don't consider willingness, bad or good, you consider the breach of the obligation. And here, in this study, 2001 and 2001, yes, that's the only condition, the breach. And then the breach may or may not cause damage, okay? And if there is a damage, then you have a secondary obligation, the obligation to repair and to fully repair. But it's not a condition. You can have responsibility without a damage, or responsibility with damage. Another ILC work, another study of the International Law Commission is about damage without wrongful act. Damage without wrongful act, which is another point, which is very different in terms of, and that's very interesting, damage without wrongful act. There is an act. You cannot say if there is a wrongful act or not, if there is a breach. Maybe there is no breach of any international obligation, but there is a damage. And then, yes, you have to repair, but it's exceptional. It's not the state responsibility principle. It's an exceptional state responsibility for damage caused to environment. For example, massive damage caused for environment. Okay. And there is a work on there is a study on of the International Commission on that point. But that's not it's not the main state of development of international law.
Okay, yes, I agree. Yes, it's very interesting. Do you want to say anything else? I'm sorry, I interrupted you.
No, we could go to the site of the ILC and I could find the study if you want, or I can mail it to Fernanda for the student.
Okay, I'll make a last consideration, actually a question, Professor. Do you believe that other dispute settlement measures help to improve the secondary obligation? I mean, are states more willing maybe to be to get the responsibility in other dispute settlement measures than in international jurisdiction? Do you think there is a difference?
What do you mean by settlement of dispute? You mean a political one or a legal one?
Yes.
A constitutional one?
Exactly, arbitration or political solution.
Yes. As soon as you are in the concept and practice of settlement of dispute, you are in the field of secondary obligation, okay? And then it's much better than the case where there is any push for the state to think in terms of secondary obligation, which is repair, cessation of the wrongful act, duty to perform. Okay. So imagine there is no settlement of dispute. There is no access to international church. It's very difficult for the state to, as we said, when you asked me the question of interpretation, you said to me, hey, I interpret your act as a breach. And I said, no, it's not. And then it's finished. So if there is a third party, of course it helps. Of course it helps.
Okay. Thank you so much.
Yeah, let's think. International law is like for you, for our student, our colleague, it's an obligation without responsibility. You have obligation, but you don't have responsibility. Or it's very, very, very weak. That's a real problem.
Yeah, that's very interesting. We're gonna keep studying about it, and we hope this doctrine, these studies, they get improved in the future. Professor, thank you so much for your lecture today. We're very happy to have you, and we will have another moderator tomorrow with you in your other lecture.
Okay. Thank you very much. Thank you.
Professor Mina, I think has a question on YouTube now.
Let me see. Yes, Carol is observing that the international responsibility is evolving. And she asks at the end, how do you see the future of international responsibility of states?
Okay, that's a good question. The future is about this study of 2001. This study should be, in the coming years, accepted as a treaty, or, if not, as customary law obligation. And I think already for a lot of states, large number of states, it is quasi-customary obligation. So either the study is leading to a treaty, or is leading for acceptation as customary obligation. That's pretty clear. And it's not very difficult to say that. It's acceptable for the state to say that. Yes, I think.
Okay. Yes. So, okay, that's it. We will have more of Professor Laurent Sermet tomorrow, okay? With a different argument, right, Professor?
Okay, thank you. Bye-bye.
Okay, bye-bye. See you later, guys.
Bye-bye.
Thank you, Professor.
Thank you very much.